I was asked to give a short history of the development of children's rights, so believe you me, I will keep it short. And a review of the context within which the convention developed back in the 80s. Especially, I think, the groundbreaking International Year of the Child, I want to put back in the context of all this. So I want to give my eyewitness view of this, not an academic piece, of what happened at the end of the 70s, early 80s. Most of you know the history, but maybe less about the pivotal moment, the moment that was International Year of the Child. I could begin by saying, long, long ago in a galaxy far away, because the start of the Star Wars saga could really be applied to the days of the drafting of the convention. It does feel very much like a galaxy far away. If you remember back then, barely 12 years earlier, the UK was still sending children off to Australia. The last children sailed in 1967. In Switzerland, where I'm now living, Switzerland was still separating children from what they considered as unfit mothers and placing them by force into farm families as a cheap source of labour. The practice continued until 1981. So it was indeed another galaxy, and it was indeed amazing that barely 10 years later we were starting to develop a UN Convention on the Rights of the Child and developing an International Year of the Child. Okay, the history. I promise I'll be very quick. 1924, Eglantine Jebb, we all know about her first set of principles relating to children, known as the Declaration of the Geneva. I have a photo here of the original, if anybody would like to see it. I keep it as one of my treasured possessions. It was the first set of principles on children's rights, basically relating to the protection needs of children. But her very interesting fifth principle says, the child must be brought up in the consciousness that its best qualities are to be used in the service of its fellow men. Interesting to reread after all this time. The 59 Declaration, of course, was inspired by the Jebb document and was said to have inspired childcare legislation around the world. A set of 10 rights, and spoke mainly again about the protection rights, but also the importance of the culture of non-discrimination within which to raise the child. The best interest principle, of course, found expression also in that document. Korczak. We cannot talk about the development of children's rights in the first half of last century without reference to that Polish doctor and pediatrician Korczak, the director of an orphanage for Jewish children, deported along with the children to Treblinka. He was a pioneer in children's rights and non-violent education, even before the Geneva Declaration of 24. And although there are different lists of the rights according to Korczak, experts tell me there is no list, but based on the interpretation of the ideas, several commentators have highlighted the right to be respected, the right to make mistakes, the right to be taken seriously, and others as key moments in our evolving understanding of children and their rights. I just want to stop in this historical overview to tell you of an anecdote, an experience that I lived through in 1989, when one of the members of my organization, who each time he came to Geneva, went to pay his respects at the tomb of Eglantine Jebb, which is in Geneva. And one year he went along to the graveside and learned that the tomb was to be destroyed. There were no more payments, so up she comes. How ironical that that was in 1989, the year that the convention was finally adopted. I'm very proud that we were able to connect with the family to ensure that her tomb will never be forgotten. And so it was in 1978 that Poland came forward with its proposal to draft the UN Convention, which they hoped, I don't know how they hoped this, but they hoped that it would be adopted during the International Year of the Child in 1979. As you know, the first Polish text was almost identical to the 59 Declaration, and so required the in-depth review we now know that happened over the following 10 years. The second draft was developed in early '79, but to ensure that the convention would be in line with what we were about to learn in the International Year of the Child, the consensus emerged to hold off and to enrich the convention with the learnings from IYC. Many NGOs at that time had indeed prepared new research, new action of all sorts to celebrate the international year that was to come. The text of the '59 declaration almost sold out. I know, because I packaged it and sent it around the world. And it was being translated for IYC beyond the 6 languages into local and tribal languages for the very first time. So what was the IYC, the International Year of the Child, and what was its impact? Well, as we know in the 70s, and maybe many people here don't know in the 70s, children's issues, children's rights, were very far from the minds of policymakers. It is all the more remarkable then that that moment arrived, that the International Year of the Child rallied so many different actors around children's issues. Over 140 countries, and remember there were far less countries at that time, 140 countries established national commissions for IYC to spearhead new movements, new research, new legislation, even initiatives to listen to children. The director of my organisation, International Catholic Child Bureau, a Belgian priest, Canon Joseph Mormon, Nigel knows very well, or knew very well, has been credited as one of the key driving forces behind that year. And it was his intuition that the year should be driven by national level action, a bottom-up year, a catalyst for all sorts of actions around the world, without any major global or high-class gala events, as they did in those days. And that certainly played a major role in the huge success of the year and the aftermath. So if I quote my esteemed colleague, Nigel Cantwell, he said that IYC was to sharpen the focus of debates around children's rights. And it was to bring an unprecedented amount of information on children's rights into the public domain. But it was also to mobilize a huge number of governments and organizations in a movement to put children's rights firmly on national and international agenda, a movement that NGOs were not ready to let die after '79. So what did IYC bring up? And remember, all this bubbling up of the International Year of the Child happened as the convention was starting to be drafted in those hallowed halls of the UN. Well, listening to the voice of children emerged as a theme of concern in many countries because it was driven bottom up. Listening to the voice of children came out, and there are so many wonderful pictures I have from those days of a truly new work. The acute needs of child labourers and their families obviously were highlighted at a time when the International Labour Organization only had $140,000 for child labour issues worldwide. I know, because I went and asked them. Children without parental care, homeless children, abandoned children, found new expression in terms such as street children, Los Muchachos. The Parking Boys of Nairobi, of course, were already known, but was popularized. And in all those issues, we were gender blind, of course. It was street boys, we'd forgotten the girls. There was a gradual realization that refugee children needed more than food and blankets, and that their educational and play needs also needed to be met. What came to be known as the psychosocial needs of refugee children gained currency very soon after the IYC. The needs of children with disabilities, the importance of the child's right to play beyond school playgrounds was popularized and competently advocated for by one major NGO. So for many of these themes, it was the first time that they had been brought to the national and certainly the international stage, and to the large audience this provided. Of course, this then led into terrific new developments in the early 80s, networks of NGOs developing and connecting to Geneva and New York child workers in Asia, an Asian-led coalition, came to Geneva, came to New York to connect and contact the committee of the evolving work on the convention. A network of children and families in Latin America, La Red, developed very quickly. The first reports on sex tourism involving boys in Sri Lanka came up very quickly. The first international report on what we call child pornography was very quickly developed. Reports on juvenile justice in a number of countries published, thanks to a new organisation that was created in the International League for the Child called, Defence for Children International. And here in the UK, Esther Ranson highlighted the plight of abused children, and the very successful Childline was born. So it's not surprising then that all the new research, the new activities began to influence the minds of those that were drafting the convention. You know, it took 10 years to draft because it was only 1 week per year that the drafting went on. The NGOs, very influential from the very beginning, actually, 1978 onwards, they were connected. UNICEF a little absent at the beginning, as we all know. I happened to sit through a very embarrassing meeting for the UNICEF head in Geneva, and of course they had no organisational policy at the time. But to be fair, most NGOs at that time had little idea of what the convention would mean for their own work. So we were grasping in the dark. UNICEF did come, of course, and played a role. And the voice of children in the drafting process. I can remember only one instance when children came from one country, older adolescents, to listen. And that's a far cry from what's been happening recently. I will quote only the new convention on domestic workers that the ILO did, I think in 2006. As I'm a former director of OAK, my memory's getting a little hazy. But child domestic workers flew in from 3 continents for that convention and successfully lobbied government delegates on several of the articles. So I just wanted to highlight these 2 parallel but interlocking worlds that were developing in the 80s. The IYC, which was a moment in time, and the ongoing drafting of that international legal instrument, the UN Convention on the Rights of the Child. They were coming together, obviously, in the minds and hearts of people, particularly at national level, and those delegates responsible for drafting, but also the increased sensitization on children's rights issues at national level, heavily influenced. So I have my sign that I'm stopping. I just want to finish with a small piece from that galaxy far away. The CRC and the International Year of the Child have had major direct impacts, and we'll hear more from Anne. But it's my firm belief, having worked at the Oak Foundation and trying to tackle sexual abuse and sexual exploitation around the world, and to help NGOs and governments put into place strategies that would look at power, economics, gender, all the major issues that you need to tackle these child rights issues. It's my firm belief that changing a nation's culture to be truly child-centred can't be imposed by laws alone, nor by international years, no matter how successful the moment. It does require that broader societal change that is much more open to children. So it does take time, and I understand the impatience of young people. Perhaps implementing more of Korczak's thinking on always taking children seriously and their right to respect and right to make mistakes might be one direction to accelerate the process. Thank you.
Good morning, everyone. It's lovely to be here. Thank you so much, the organisers, for inviting me. I'm, as you've heard, very new on the Committee on the Rights of the Child. So my observations are not really the observations of an insider. I'm more, like yourselves, used to looking at the committee from the outside. In fact, only last year I was there with the South African Civil Society delegation presenting our alternative report. So I'm far more used to looking at the committee from the other side. But I think that there is a lot that can be said about the achievements of the Convention on the Rights of the Child. And I'm going to try to focus on something that I know something about, which lies particularly in the field of law and litigation. But let me say that one can list many things that have happened since the Convention on the Rights of the Child, but these are all things that are well known, that if you visit the website of the committee, you'll see many of these things. There have been 20 general comments, 22 days of general discussions, 75 sessions, I don't know how many thousands of meetings. They always start the meetings by saying, this is the 1,750, and when it's in French, it's very confusing. And then there is the pre-sessions with involvement of INGOs and the NGOs, and the important role played by Child Rights Connect in ensuring NGO participation has been particularly successful, I think. 3 optional protocols, one on children and armed conflict, another on sale of children, and then of course the new one, which is creating a communications procedure, which takes the committee into a whole new terrain. There have been new working methods, and Jaap Duk, who's here, was the one who introduced the 2-chamber working method, and he told me last night that it was actually very controversial at the time. The states parties were very worried about it, but it was the only way that the committee could keep up with its workload and make sure that states parties got the feedback that they needed in terms of the reports that they were submitting. There are webcasts, so there was live streaming, and so one can say the committee's gone a long way. However, many of these things are happening in the other treaty bodies as well. But what is, of course, quite unique to the Children's Rights Committee under the Convention on the Rights of the Child is the role of child participation. That it is, of course, always referred to as the pillar of the Convention, and the committee has made an effort to make this principle part of the practice of its own work, particularly in the pre-sessions. And I can imagine, and we heard then from Florence, that at the time of the drafting of the convention, there wasn't very much participation. And I'm sure that in those days, having children come in at the front door of the Palais Wilson, or is it the back door, anyway, the door that we all go in, at the Palais Wilson, would have been very unusual. Well, now it's quite common that there are children coming in and out of the building, children coming and speaking. Of course, there's a lot of room for improvement. One could still say it's a very privileged few children because of the cost of getting to Geneva that get to come and talk, usually on behalf of a group of children or many children that they're consulted with beforehand. But the committee is starting to use technology, and just in this last pre-session we interacted with children in Sri Lanka using the video link-up method, which is a good way of getting more children involved and being able to hear from more children all over the world. Very important, of course, has been the demonstrable effect on law and policy all over the world. And a 2013 UNICEF study has shown that over 70 countries have introduced dedicated children's laws to come in line with the CRC. And many modern constitutions now contain a child's rights section, very often drawn from the Convention on the Rights of the Child, and my own country, South Africa, is one of those examples, because our constitution was drafted in it's the 1996 constitution, so it was after the Convention on the Rights of the Child, and many countries that have got revised constitutions and bills of rights since the convention have included a children's rights clause, and that's obviously very important. Almost universal ratification is another unique feature of the Convention on the Rights of the Child. And we all know who that one country is that's spoiling it, so that we can't say universal ratification. But even they've ratified the first and second optional protocols, and the very first day of my involvement at the committee was the United States of America reporting on the optional protocols. So that was very unusual. And that kind of breadth of ratification from a legal point of view makes the Convention on the Rights of the Child probably international common law. I mean, the only country that's really important for is America, and because it means that the convention has some binding effect, or at least persuasive effect, on America too. And the case of Roper versus Simmons, which some of you may know, which is the case that struck down the application of the death penalty to children in 2005, actually did consider the Convention on the Rights of the Child. And although there were grumpy dissents from Justice Scalia saying that they don't look at international law and they don't care unless it's the English law of 1670 something, the majority of the court said, we do have to look at it because it tells us about evolving standards of decency, and that's the measure used by the Supreme Court. How can we think about evolving standards of decency and not notice that everybody else in the world has signed up to this convention, and that almost all other countries in the world had at that time done away with the death penalty for children. And so this was a huge impact on even that one country that hasn't ratified the UN Convention on the Rights of the Child. So as I mentioned earlier, the South African Constitution, I hope you won't mind me talking about my own country and my own experience, but obviously it's something that I know a lot about, and perhaps something that isn't always widely known about is some of the work that we've been doing using the law and using our own constitution, which is based on the Convention on the Rights of the Child. So there's a full section, section 28 is the section, but I've chosen to pull out the one that relates to alternative care, because it is obviously the theme of today's meeting. And so the clause says that every child has the right to family care or parental care, or to appropriate alternative care when removed from the family environment. And we talked the day before yesterday about the importance of this phrase, alternative care, and you can see there it is in the South African Constitution, often remarked on as the unusual order of family care coming before parental care in this clause. What the Constitutional Court has said quite clearly, though, is that they don't see these as equal alternatives, and they definitely recognize alternative care as only coming into place when parental or family care is not available for children. So I want to tell you the story about two cases that are relevant to this aspect of law, alternative care. One of them is called M versus the State, with Centre for Child Law, where I work as the amicus curiae. Amicus curiae means friend of the court. In your systems, you may have friends of the court, or you may be more familiar with the term third-party interveners. It's a party that can enter in and can also influence the outcome of the case. So Ms. M was a woman who had been convicted of fraud, and multiple counts of fraud, and she had 3 children, and it was apparent that if she was sentenced to imprisonment, which the lower court had sentenced her to, she would be separated from her children, and the children would have to go into care. So she appealed, and the case ended up in the Constitutional Court. The Constitutional Court decided to actually invite the Centre for Child Law as an amicus curiae to come in and argue what the court's position should be and what their approach ought to be when primary caregivers were facing imprisonment. And the South African Constitutional Court established a new rule in this case that said that henceforth, whenever a court is sentencing a primary caregiver of children, that court has to take into consideration the impact of imprisonment and what that would mean to the best interests of the child. It's a very important judgment for a lot of reasons, because it also articulates what is meant by the best interests of the child and what is meant by the paramountcy principle. The court said that section 28, that's the convention, the Constitution's section on children, must be seen as responding in an expansive way to our international obligations as a state party to the CRC. Section 28 has its origins in the international instruments of the United Nations. Thus, since its introduction, the UNCRC has become the international standard against which to measure legislation and policies. This is the South African Constitutional Court. It's 11 judges that sit en banc. They all sit together all the time. As you can see, it's a very interesting, unusual setting with a kind of semicircle. Very interesting building. If you're ever visiting Johannesburg, please go and have a look at it. They don't mind tourists coming in. Anyone can come in and sit. And there are often children, school groups, coming and sitting in on the Constitutional Court deliberations. So the court also said, regard accordingly has to be paid to the import of the principles of the CRC as they inform the provisions of Section 28 in relation to the sentencing of a primary caregiver. The four great principles of the CRC, which have become international currency, and as such guide all policy in South African relation to children, are said to be survival, development, protection, and participation. What unites these principles and lies at the heart of Section 28, I believe, is the right of a child to be a child and to enjoy special care. And these are very often quoted words that we like a lot because they, I think, speak so much to what children's rights really mean. Justice Sachs, who wrote these words, said, "Every child has his or her own dignity. If a child is to be constitutionally imagined as an individual with a distinctive personality, and not merely as a miniature adult waiting to reach full size, he or she cannot be treated as a mere extension of his or her parents, umbilically destined to sink or swim with them." The unusually comprehensive and emancipatory character of Section 28 presupposes that in our new dispensation, the sins and traumas of fathers and mothers should not be visited on their children. And he says, individually and collectively, all children have the right to express themselves as independent social beings, to have their own laughter as well as sorrow, to play, imagine, and explore in their own way, to themselves, to get to understand their bodies, minds, and emotions, and above all, to learn as they grow how they should conduct themselves and make choices in the wide social and moral world of adulthood. And foundational to the enjoyment of the right of childhood is the promotion of the right, as far as possible, to live in a secure and nurturing environment, free from violence, fear, want, and avoidable trauma. Hope you don't mind that I'm reading this, but I certainly couldn't say it better. And so the court went on to say that, the court couldn't isolate children from all the knocks that life might bring, but the court said that the law can create conditions to protect children from abuse and maximize opportunities for them to lead productive and happy lives. Thus, even if the state cannot itself repair disrupted family life, it can create positive conditions for repair to take place and diligently seek wherever possible to avoid conduct of its agencies which may have the effect of placing children in peril. That is Justice Sachs up in the corner. I don't know what you know about him, but he was targeted when living in Mozambique during the apartheid years by apartheid mercenaries who put a bomb in his car and blew his right arm off. But he then later came back to South Africa and sat as one of our justices in our Constitutional Court. He's now retired, although he hates the R word. So he was very important. Just 2 more minutes would tell you about another case which had to do with children. This is the news story back in 2010. Children being accompanying their parents begging at the side of the road, and some of them were working at the side of the road. The city police and social workers swooped and removed the children in a kind of dramatic, thing, because this is the kind of thing the public complained about. Why are these people using their children to beg? And the authorities moved in and grabbed the children. So we went to court to get the children back for the parents, but ultimately we also used this opportunity to pick up on a flaw in the law, which was that when children were removed from their parents, there was not an automatic review of that decision immediately afterwards. And the social worker could take 90 days to do the investigation before the matter would come to the children's court. And so that we felt was unconstitutional. And this case is called C, and C and M were the 2 parents whose children were removed. And this case also was very important, and I'll just pick up there on the second part of this. Of course, we also have the advantage that we can draw on the African Charter on Rights and Welfare of the Child as well as the CRC, and our court often does that. But Article 9 was something that the court looked at very carefully, and you can really see in this judgment the impact of the convention. because we were able to argue that in the light of the convention, you had to interpret our law as being unconstitutional if it didn't allow for a review by a court, because it talks about subject to judicial review in Article 9.1, and on the basis of that, our court inserted into the law a requirement that when any child is removed from a parent, on the next court day there has to be a hearing, and the court talked a lot about the participation rights of children as well. This is Justice Squia who wrote this judgment. He said the right to parental care or family care requires that the removal of children from the family environment must be mitigated in the manner described in the CRC in order to satisfy the standards set for the limitation of rights under our Constitution, the requirements that the removal be subject to automatic review and that all interested parties, including the child concerned, be given an opportunity to be heard, in my view, stands as essential safeguards of the best interests of the child. So as you can see, the CRC used in litigation can be very powerful for changing the law at the domestic level. In South Africa, the Centre for Child Law specialises in what we call strategic litigation, which is more and more being used in many parts of the world. It does obviously require independent judges, it does require a good constitution, but more and more countries have that now. I think that this is just one of the ways. Yesterday, Nigel talked about the importance of words. And I've read a lot of the words here because I think these words are very important. Obviously, words with no action are useless, but words that are catalysts for action, I think, are powerful. And we can see the words of the convention trickling down into the words of the judgment, which must then trickle down into the lives of children. Thank you.
Looking at this room, I especially enjoy the view of a very young doctor who is not even 1 day old. That very young doctor confirms that if you are involved in children's rights, it keeps you young. Secondly, you are never too old to learn from the Convention on the Rights of the Child. You all know that there is a very important provision in the Convention and in other treaties as well. Children have the right to be registered immediately after birth. One of the reasons for that is that we need to know how many children there are in the country to make an effective policy, for instance, education or healthcare. Question: does that article apply to stillborn children? I'm not going to give you the answer, you need to think about it, because I'm going to talk about something else. Child protection. I become a little bit alerted when we are talking about child protection systems. We have a juvenile justice system, we are going to have a child protection system. What alerts me is the fact that systems usually turn into rather developed bureaucracies and a lot of power in the people who are maintaining that system. And gave some examples of intervention in South Africa. There is an interesting comparison to be made between those two systems. The juvenile justice system, as you know, deals with a juvenile in conflict with the law. Since we have made the term juvenile delinquent a taboo term, and if we want to communicate with the people and we're talking about a child in conflict with the law, we have to start to explain what we mean with that. But nevertheless, juvenile justice, there is in the juvenile justice a very powerful player, the state. The state is represented by the prosecutor. The prosecutor has police support and availability, collect evidence, interview witnesses, interview the alleged perpetrator, the child, there is a court with the full power to make decisions. And that was a reason for not only the Convention on the Rights but other treaties as well, to try to provide that person who is subject of that particular system, the child, to make the child equipped with rights that move to what is known, at least try to come as close as possible to equality of arms, and provide the child, read Article 40 of the Convention, paragraph 2, the child is provided with a number of rights, which are meant to at least try to get a kind of a balance in the system. But the child is provided with legal or other appropriate assistance, but the child can, if necessary, if the child wants to do it, but usually it's his lawyer, question witnesses, is provided with an interpreter, has the right to appeal. That's all the juvenile justice system. Now the child protection system. The Convention on the Rights of the Child has a very, in my view, serious shortcoming. We want to protect the child. We have a system, or we have a practice, an organized practice, and in some countries, including my own country, a real well-developed system of child protection with agencies with power to enter the court with requests for child protection measures. Parents and children are considered to be the beneficiaries of this system. Legally, it's usually a procedure that is focusing on the authority of the parents to limit their authority through a supervision order, or to even separate the child from her or his parents. Article 9 of the Convention, and already referred to it, has a provision that requires state parties to make sure that all parties in that particular process of separating a child from her or his parents to participate, to have a full opportunity to express their views. For the child, it's repeated in Article 12. There is the possibility to express your views. Your views as a child should be taken into account. Whether you are heard by the judge, in a number of countries it's a lottery. You can say there is no age limit. Every child, read General Comment number 12, every child, the presumption is that every child can express her or his own views. And there are a lot of other observations. In legal procedures, what's the capacity of the child to form her or his own views? It's left to the judgment of adults, in particular the judge, and if there is no further instruction for the judge, he or she can make up her own mind and say, well, I consider this child as not capable of forming her or his views, and I'm not going to hear her. So that about the right that is in the Convention, the right to be heard. The assumption that, or let's say, my perception of the whole system is, we believe that what we do in the child protection system is in the best interest of the child, so there is no reason for any further guarantee to make sure that the child is not run over by the best interest as we see it. So the child has no assistance in the court, no legal or other appropriate assistance. There is no provision in the Convention, and nor in my country, where it tells that a child who cannot speak the language that is used in the country is entitled to an interpreter. The child does not have the right to appeal from a decision of the juvenile court to separate her or him from his parents or her parents. So, when it comes to guidelines on alternative care, one of the things that I was missing there was exactly this particular set of guarantees. As soon as we develop a child protection system, make sure that the child is not lost in that system, and make sure that the child is provided with the tools that makes it possible to tell all of us, you go to hell with your child protection, I want to stay with my parents. Full stop. Thank you very much.
So our critical question is, we know, and we've heard in this session, that there might be a lot out there in terms of law, lots in terms of words, but how well is it trickling down? What does it mean in terms of implementation? And so we want to know from you if you were to make a list of the top 3 things that need to happen to ensure implementation of the Convention on the Rights of the Child, what would they be? What are the 3 things? I mean, obviously there are many things, but if we were going to try and rank them, what are the top 3 things that you think could best ensure the implementation of the Convention on the Rights of the Child all over the world at the national level?
Thank you. Just before we get into sort of a broad discussion, could I ask you to turn to a couple people around you and really just think through for 2 minutes what your first thoughts are about that? I think it's a fantastic question. What are the top 3 things that we would need for implementation? And I'm imagining that within that question there are the implications of then what are the barriers? And also may I ask that we think about the other subtext of that question, which is perhaps what have been the driving factors that have been successfully implementing the guidelines as well. So we think about barriers as well as facilitated drivers, but ultimately the question is what are the top 3 things that we need for implementation of the Convention on the Rights of the Child. I hope you've had a chance to introduce yourselves. I realize I should have suggested that because we don't have a delegate pack for you. So if you haven't introduced yourself about who you are, then please do to each other. And this is a dreadful thing to stop the conversation because I know you've already got launched right into it. But really, what we'd like to do is try and capture these your thoughts about this. And I might suggest that I ask for we've got rolling mic that Michaela is going to. This is Michaela, who's a researcher at CELSIS. Delighted to have you help us. Thank you. And we're going to just run around and just capture a few of your thoughts. I'm going to ask you, if I may, to be as concise as you can, despite the complexity of the issues. And what we'll do is, as we're hearing each other, we're going to want to think about how it builds on what we've heard that's been so valuable to hear from Anne and Jaap and Florence, but also what the themes are that are emerging that we can build and develop through the day. So let's start by your first thoughts about what are the key things that we need for implementation.
Cathy McCullough from Children's Parliament. So the first thing that we thought was a public awareness raising exercise, really fully and centrally supported by the government, in order to help people understand that UNCRC and domestic legislation aren't just words on paper, but to demonstrate the impact that they have. And we think that children and young people should be involved in bringing that alive and helping people, adults, understand what the impact of that is themselves, rather than relying on adults to do the mediation aspect of it.
Great, thank you, Cathy. On that note, can I just reflect on something that Florence, I think you'd mentioned, in terms of the International Year of the Child. And as a Canadian, Susan and I are both Canadian, we were speaking yesterday. So I was 10 in 1979, and it was transformative for me in terms of the work that I do, and my interest in rights was the national public awareness campaign around children's rights related to the Year of the Child. I think there's something really valuable to go back to understand, not just about some of the headlines you gave us about the national ownership of that, but also, and what else, what can we learn about the also successful in shaping the wider sort of psyche of a culture and around children's rights. So thank you, Cathy, that's great. Other thoughts?
We also agree with Kathy that if children don't know that they have rights, how can they be implemented? If government doesn't know how to implement a child rights approach, then how can they integrate that into policies and legislation? So public awareness and understanding was one. Another was around the incorporation of the UNCRC into domestic laws, because unless it's actually enforceable in law, then there is no binding commitment on governments to embed a child rights approach into policy and practice, and it comes down to discretion, and they can pick and choose where they want to do it and where they don't want to do it. And obviously that needs to be also accompanied by legal aid and access to justice to children and young people, because even if it is included in law, unless children and young people have the opportunity to enforce their rights, then it doesn't really make that much difference.
And to pick up on that last point, I think the issue of education and raising awareness is crucial, but it's not just at state government level, it's very important, it's at a community level. And I'm thinking where the UNCRC butts up against traditional custom and practice, female genital mutilation is one of the most extreme examples, but smacking in this country is another, in terms of moving from the state level down to the community level.
The ongoing training that's needed for the new generation of social workers, lawyers, etc. that are coming forward, ongoing on children's rights. In my work we've noted a huge gap on that in various parts of the world. And then a suggestion about no child leaves primary school without knowing about the UNCRC and their rights.
Thank you.
And my issue was budgets. You know, we need to start influencing state budgets in a child-directed way.
Just in terms of the training issue, I think one of the real issues that we've got to tackle is that people learn together so that there are common understandings, because we continue to train people in silos and then somehow or other expect that when they come out into the world of practice they've got a common understanding. So unless we start looking at the curriculum and saying where do the teachers and the social workers and the nurses and the lawyers and whoever else learn about the convention and children's rights together so that they come out into the world of practice with a common understanding of what it is that needs to be done, then I think we will continue to have problems of differential views of the interpretation of that.
We would agree with Peter, and I discussed political will and resourcing. I think also we're just building on the points that were made by Juliet and Kathy. How are we moving on? Yes, participation and yes, consultation with young people and everything, but how are we moving that agenda towards youth-led and child-led driven activism and advocacy for the change? I also think we have to recognise that we do face very specific challenges, particularly in the international arena. The pushback from the traditional values crowd, the rhetoric of the protection of the family that we face in numerous annual resolutions now, is a pushback against universal human rights. It's not just a pushback against children's rights. So we do still have to recognise that we face challenges and be ready for them.
We listed out three priorities as incorporation, education and participation. So we're picking up on a lot of points that were been made by Juliet. I just wanted to add maybe some extra things to that, is to say that the incorporation and education probably go hand in hand. Well, one of the biggest things we could do to raise public awareness would also be to incorporate international law, which forces people to become aware of it without having to spend money on a large public awareness campaign, but you could do both. Education, we want people to understand rights in an abstract level sense, but perhaps more importantly understand how that applies to their lives in a very practical way. And in participation, yes, we think an increased right to legal aid for children is hugely important, but I would say as an advocacy organisation, we're very keen that there's a right to advocacy for children who are in care, which is not currently the case. And it is simply not available in huge parts of the country. And we hear stories from the Legal Aid Board, who I met with recently, who told us that very often they'll have children applying for legal aid, where in their view it would be better off for them to have an advocate, but there simply isn't one available. So we would like to see that become a focus as well.
David Watt, we had discussed the gap between the fine words and the legislation and how it takes place in practice, and the need to take account and measure and evaluate and use data identify where those gaps are, identify our strengths and what we're doing well, and begin to move into those areas where it's less good practice and push and ask people to take account to improve that situation.
Great, thank you.
Hi, my name is Don Cipriani. I'm the director of Ignite Philanthropy, inspiring the end of violence against girls and boys. So I'm speaking on behalf of myself, not the group here. I guess I'd just like to add a bit of an edge to the various comments on public awareness, youth awareness, understanding, training, and access. And I think it's helpful to go a step beyond that when we think about children and youth participation. And I know that this needs to be nuanced in the context of evolving capacities of children, but recognizing children as the best advocates for themselves and supporting them in that to be active in asserting their rights, their moral claims. That's, I think, the real power of rights and the real power. Not just awareness, understanding, but grassroots organizing, right? And enabling youth to form movements to express their views and hold governments accountable. So yes, we want awareness raising with support of government, but what we really want is youth and children, I think, to assert their rights for themselves.
It's really just a comment that we had that follows Florence's observation about the training of new professionals. We were actually saying that it's not just the new professionals, it's actually today's professionals. If you were to stop group of teachers, social workers, police officers, paediatricians, nurses involved in child protection today and ask them a few basic questions about the CRC, I think they would struggle. So it's that dimension as well. Thank you.
Thank you. Can I add to that, Roger, if I may, just to reflect on our experiences in Scotland in relation to implementation. So you'll know that our centres here are really committed to understanding how we make things real in practice, and our interest is very much about what does the evidence of implementation say to us, and some of these are very key to what we know. I think that very question about taking the rights and training and raising awareness of staff is most meaningful when we're actually able to say, what does this mean that individuals say, what does this mean about what individuals say and do differently in their day-to-day engagement, in their work with children, young people, families. And until we can get that rights translated right through to understanding what does that mean for how I'm engaging and how I'm understanding the person in front of me, that traction won't be entirely, that alignment won't happen entirely effectively. So at all those levels, isn't it? So I'm entirely agreeing with you in adding a little bit more in terms of our understanding all the way down to what does that mean for individual workers, not just understanding the rights from a conceptual basis or a legal basis, but what that means in my practice. Any other comments?
Learning and working together is also important, and because we need to move forward from working in silos to working together, and a barrier regarding this is the lack of coordination sometimes between different institutions, local level and national level. And working quite a lot with UN Committee of the Rights of the Child general comment regarding the implementation of the UN Convention. I think that's a very powerful tool that could be somehow translated and picked up by governments in their work. And there is also some, in my opinion, some work that the committee could do in promoting these wonderful tools that they developed to support the implementation, and they are there.
Talking about breaking silos, there is the women's rights movement as well. And I think the child rights movement needs to be much braver. And if we're talking globally, if we're talking all the issues in the convention, I've certainly come up against a lot of issues in my last 18 years in Oak Foundation, discussing issues of sexuality, early marriage, child sexual exploitation, where there hasn't been a conversation. So I think we child rights people need to be bold. Those conversations are starting, so let's be constructive, not conflicted. Thank you, Nigel. And let's open up and break the silos, because that's important too, that the exposure to child rights is also in the women's rights movement.
Of course, we have to break silos. If you one of my recent experience in training judges, training police officers, you want to talk with police officers about their problems, don't do that when the prosecutor is in the room or the judge is in the room. You want to talk with judges about their problems in implementing children's rights, don't do that in the room with lawyers. So, the problem of breaking silos is important, but allow silos from time to time. Because if you want to really know what the problems are of some of the professionals, you don't get that problem if there are others in the room who maybe benefit from the problems of the judges or the other way around. So you can do that, but I think sometimes silos are necessary to get to the bottom of those silos.
Good morning, Susan Bissell here. This is not what Dan and I worked on, as everybody said, everything that's on our paper, but it's more of a reaction. And I think the sort of top-down work and informing about rights and all of that is incredibly important. But I think there's a huge area that is ripe for further research, which is understanding community-led, family-led processes of social change, which result in better dignity for children, communities, et cetera, et cetera. And I'm thinking about a lot of the work on female gender mutilation and cutting child marriage around the world. So I think not to get, I'm not saying anybody is, but stuck in that kind of, it's about some international legal treaty and ignoring that, those positive social change that is taking place in many places.
That's helpful, thank you. Dan, this is slightly off the wall, but many, many years ago, one of the things that governments always said was they couldn't really afford to implement child rights. You know, they had too many other priorities, the resources were limited. Some years ago, a young man wrote a paper called Child Rights-Based Economic Policy, and he had a rationale for how you demonstrated that investment in child and human rights actually had a much wider benefit to the economy, social capital and human capital. And I think it would be really good for an organisation or many organisations to explore those options, because the big thing was cost. And if you actually can demonstrate that there's a benefit to investing in this that is beyond not the mere benefit of rights, but to support rights in a very practical way, I think that's very useful.
I swear this wasn't a setup. Thank you, Diane. Because I actually wanted to build from both Juliet and on the question of budgets. And for all the laws we put into place, they have to become policies, and those policies have to be actually put into place in action. And Anne knows this very well, as she's made that happen in South Africa by ensuring that the budgets were there first. So that can even be done from the bottom up. Ask Anne if you want to know how that's done. But I want to also just talk about from the government level, the political will that's necessary. Now we will be talking about the importance of political will. Political will has to translate into dollars and cents. And that's very clear in the CRC itself, where Article 4 says that the states must invest in child rights to the maximum extent of available resources. Well, what on earth does that mean? The committee has worked together with many of us in the UN and civil society to come up with General Comment 19, which tells you exactly what that means and exactly how to implement it. And that can actually be used at local level as well as at state level. It can be used by local governments as well, as I learned as I learned yesterday evening from Juliet and the work they're doing here in Scotland. It's about investing. It's not only about how much you spend, but about how well. And that is also taken up in that general comment. So not only how much resources are you spending, but are they being spent efficiently and effectively and equitably?
I think it's the one on public awareness and particularly a societal understanding of the rights. That can be obviously quite a complex situation, but something which can be relatable in stories, and I think there's a new role for the media to play in capturing some of the amazing work that's going on an individual and a collective basis with young people, and to try and get those positive messages out. That these rights are relatable and they're deliverable for individuals.
this may sound like a few other conferences ago where we've seen certain things coming back and back, training, there are lots of new things here. But I think we're encouraged by the fact that there is a lot of things happening there, and that there's places to build on globally. I don't know about Scotland, but globally there are areas to build on. And the boldness that I think we felt at the time of the drafting of the convention, we've got to bring that back again, we've got to find that again, and we've got to be bold and go to the World Bank, and we've got to go to the IMF, as people are doing, and taking child rights there and asking questions. So let's just continue to be bold is the thing, and build on all the good stuff that's happening out there.
There are perhaps people from different countries. Can you raise your hand when information on children's rights is a mandatory part of the primary school curriculum? In which country is that the case? Examples?
Scotland.
Scotland?
Health and wellbeing experiences and outcomes include within it across 5 to 15 consideration of children's rights.
Okay. And that applies to secondary education as well?
Yeah.
Okay. Okay. Because there are too many countries. Because we are talking about information, awareness raising and all that stuff. And you have children ombudsperson, with due respect for the new one here. They distribute flyers once every so many years in schools about children's rights. They have teachers who are perhaps interested to do something voluntarily on children's rights. Talking about political will and talking about money, you want to raise a generation that actually knows what human rights of children are, how you can use them, and also make them aware of the fact that rights are not the same as claims, but have also obligation. Because it's one of those usual questions you get when you talk of children's rights in an audience. There is always somebody who says, oh, what about the obligations of children? I didn't hear anything about the obligations of children. You're talking all the time about the rights. So, you want to have a goal for the next 25 years, make sure that in all 196 state parties, information on children's human rights is a mandatory part of primary and secondary education. That's raising a generation that understands human rights in general and human rights of children. And just as a reminder, there is a tricky question, how many countries are committed to implementing the Convention on the Rights of the Child? What's the usual answer for those people who know? 196. That's the wrong answer. That's the wrong answer. Well, you say, well, there are 196 countries who have ratified the convention, so what's wrong with that answer? That answer is wrong because you forgot a country. They did not ratify, but is committed to implementation. And that country is Taiwan. So there are actually 197 countries in the world committed to implementing children's rights. Only one not yet. But it will happen. And I hope you will be a witness of that particular very important event.